right now. So joining us live is Northeastern law professor Daniel Medwed. Thanks so much for joining us again, Daniel.
Hi, Antoinette and Jessica.
Okay, so let's get right to this. The moment this news broke this morning, I've been trying to wrap my head around why would Brian Walshe change his plea like this? What is the strategy for his defense team?
I think the strategy, Antoinette, he probably wanted to get a favorable situation at the trial, because instead of making this a whodunit, it's now a what happened. So what I imagine he'll do is he'll argue that this wasn't a premeditated killing. That's first-degree murder. That's the charge he's facing. Without knowing, of course, what's going to happen at trial, I imagine he'll suggest that something happened that was a bit aberrational or unexpected. They had a fight, or it was a spur of the moment incident, something like that. So maybe he's just gauging, he's angling perhaps for a murder two or manslaughter charge.
We know now, Daniel, that they're in the middle of jury selection. The question is, how is this going to impact the jury? I mean, are they going to bring up this change of plea, or how does that work?
Well, the jury will know, I think, that the only charge here is the murder charge, which means that there will be evidence presumably presented about his behavior in the aftermath of the accusations or the police investigation. So the jury's going to learn all about the mishandling of the body, how he also misled the police. So I think, I mean, it could boomerang against him. I don't know what you guys think, but the jury might think, hey, a person who treats his wife's body in that fashion, who misleads the police in that fashion, probably killed her in a premeditated manner. It could be boomerang. We don't know.
As far as jury selection goes, because of course that was the original reason we were keeping an eye on this morning, and then these big developments happened. Getting back to that jury selection, is there even a way that jury members, potential ones, don't hear about this or haven't heard about this case at all? Is that really reasonable in the society we live in these days?
I think you're right, Antoinette. It's not really reasonable to expect that unless the jurors are living under a rock, that the jurors haven't heard about it. The key question, the litmus test here, is given what the jurors know, are they still able to put that aside, put away any preconceptions, and look at the evidence with equanimity and objectivity? Now, the litigants have a certain number of what are called peremptory challenges, where they can excuse jurors or reject jurors for no articulable reason. So I think the lawyers are going to use those challenges, and each side has 12, quite carefully here.
All right. Professor Daniel Medwed, thanks so much for joining us.
Always a pleasure.
Great.
Thank you.
Always great to get your insight. Okay, News Center 5 will have you covered every single step of this trial. You can find Sarah Conji's notes with minute-to-minute updates on WCVB.com. And as soon as those opening statements begin, we will stream every moment of the trial on our website, the WCVB News app, as well as our YouTube page.